Okay, good afternoon, everyone. Thank you for joining us today. We're looking forward to speaking to you about FINRA's new Rule 3241. My name is Joelle Sims. I'm a principal at Bressler, Amory, and Ross in our Dallas, Texas, and Fort Lauderdale, Florida offices. I am excited to have Beverly Jo Slaughter from Wells Fargo moderate for us today, and also to have my fellow co-panelists Sarah Soto and Andy Egan present. Just some housekeeping real quick. You should have received an email with the CLE verification form if you are seeking CLE credit. We will be announcing the codes throughout. There'll be 2 of them throughout the presentation. I'll also put those up in the chat. Without further ado, I will turn it over to Bev to get us started.
Well, good afternoon, everybody. What a delight to have this opportunity to speak to you about this new rule. Since we've already introduced ourselves, Joelle, can you help give us an overview of the new rules so we can get started on our discussion?
Absolutely. So for those of you who are not aware, FINRA Rule 3241 went into effect a little over a month ago on February 15th. The rule basically breaks down obligations both of registered representatives as well as firms. So in the first instance, the registered rep must decline being named a beneficiary, receiving a bequest, or holding a position of trust, such as executor, trustee, power of attorney for a customer, upon learning of such status. So, and we'll talk about this a little bit later, but this is important. Obviously somebody can't turn down a position if they are not aware that they have been named or are not aware that they have been put in someone's will. It's upon learning of these status. And that is unless there are one of 2 things. The first is that a customer is an immediate family member, or the registered rep provides written notice to their firm and receives written approval. In the context of serving in a position of trust, such as executor, trustee, or power of attorney, there's an additional requirement that the registered person cannot derive financial gain from that position other than what is reasonable or customarily charged for such a role. Now, before we get to the obligations of the firm, there's a couple definitions that are important to review. The first is, what is a customer? So the FINRA rule defines a customer as someone that has, or in the previous 6 months had, a securities account assigned to the registered person at any member. Second important definition is an immediate family member. And I won't read everything here. It's up on the screen and also in the rule. But as you can see, quote unquote, immediate family member is defined quite broadly by FINRA. It's not just mother, father, child. And finally, this should probably be intuitive, but if a registered rep declines a bequest, beneficiary status, or serving in a trust position, the rep is not allowed to instruct or ask the customer to name someone else, such as the rep's spouse, child, or other relative, in the registered rep's place. Now, on to the member obligations, which is what I'm sure everyone is most interested in who's attending today. If a member firm receives written notice from a registered rep, first, it must perform a reasonable assessment of risks created by assumption of the role. Second, it must make a reasonable determination of whether to approve with conditions or limitations, or deny the request, and they must advise the registered rep of that determination in writing. Now, importantly, if the firm decides to approve the activity with conditions or limitations, the firm must reasonably supervise compliance with those conditions and limitations. Now, finally, as with any FINRA rule, the firm has to have written procedures to comply with the rule and also has certain record retention requirements. So what is a reasonable assessment determination? The rule does not tell us. Fortunately, FINRA did issue some guidance in Regulatory Notice 2038. And in there, they listed what they called a non-exhaustive list of considerations. So these are things that firms should consider, but there are potentially other things out there that firms can and should also consider. So the first is potential conflicts of interest associated with the position of trust or being named as a beneficiary. The second is the length and type of relationship between the customer and the registered representative, the customer's age, the size of the bequest relative to the customer's estate, whether the registered rep is a serial inheritor or has received bequests or been named as beneficiaries by other customers in the past, whether the customer has a mental or physical impairment that renders them unable to protect their own interests. Now, interestingly, the rule does limit this, or not the rule, but the regulatory notice, and says based on facts and circumstances observed in the member's business relationship with the customer. So there's no sort of insinuation within this guidance that the firm should be requesting medical records. which frankly makes sense because firms are not doctors, and I'm not sure they're in any position to interpret medical records. Next is any indicia of improper activity or conduct with respect to the customer's account, such as excessive trading, things of that nature. And finally, any indicia of customer vulnerability or undue influence of the registered rep over the customer. Now, importantly, in this notice, it does instruct that if possible, there is an expectation that the firm discuss potential beneficiary status or position of trust with the customer as part of its reasonable determination. Now, obviously, this part is really relevant only in those circumstances where the representative is aware of the status. You know, if you have a situation where the client has passed away and the rep is learning for the very first time that they have received a bequest, that's obviously not going to factor into the determination about whether that rep should be allowed to take that bequest or not. Now, finally, FINRA gives some guidance in this rule as to what should be done regarding pre-existing designations. Now, if the rep was designated as a beneficiary by or served in a position of trust for a prior firm, where the firm approved that, the registered rep must submit written notice and receive written approval to continue that status within 30 calendar days of becoming associated with a member. So if the rep is at firm A, they've gotten this status approved at firm A, they decide to move to firm B, they have to resubmit the approval with firm B within 30 days and receive a written approval as well. And then second, if the registered rep held the role prior to the existence of a broker-customer relationship, same thing, got to submit approval and get it approved by the firm in the same way. So let's say someone has a neighbor, they've been, you know, the trustee of the neighbor's trust for however long, the neighbor decides to become a client, you have to undergo this analysis and they have to submit for approval.
Thanks so much, Joelle. So I'm wondering, how prevalent is this issue? Has it come up a lot, your experiences with it, Sarah?
From the litigation standpoint, this is not a very prevalent problem, but it is prevalent enough that it should be, it raises concerns and that it should be focused on. In the cases I've had involving this, and I can think particularly to one of them, it is horrendously expensive for the firm to litigate claims of that nature. And so you find yourself in a situation in which the firm has derived a little benefit from a relationship. Often these claims are brought by third parties who, you know, other beneficiaries or other family members who have absolutely no relationship with the firm. In short, they have produced no income for the firm. They don't really have a relationship with the firm, but they bring a claim. And the claim must be defended. And the defense, given the fact that these people are not in the traditional customer relationship, tends to be very, very expensive. They also have a lot of emotions tied up in the situation, so they tend to continue to fight as opposed to resolving matters on a rational basis. So I would say it doesn't happen that often, but when it happens, it's quite memorable.
I understand. And do you think this rule will represent a sea change for broker dealers, or is it something that they've probably already been doing?
I think it's something that brokerage firms, at least major brokerage firms, have already been doing to some extent. To me, the issue is whether this will provide the firms with an opportunity to say, okay, there's a FINRA rule, I followed it, why are you suing me? As opposed to in the past where generally you would look at the firm policies and you would be judged based on abiding by firm policies.
Yeah, and I would add, I mean, I think, you know, depending on how firms have historically dealt with these requests, the rule could create a sort of safe harbor to allow things. So let's say you've had a particular firm that historically never allows this. They just say blanket policy, we don't allow anybody to do this. Or let's say you have a firm that says you can only do this for family members, but not for anybody else. This rule signals, by the very terms of it, that there are circumstances recognized by FINRA in which serving in one of these roles, a position of trust, bequest, or beneficiary for a client can be appropriate. It specifically says these are the circumstances you should consider, and it's not, you know, per se a no-no to do this. And I think, it's important to remember, oftentimes when we sort of think about an FA receiving a bequest or being named as a beneficiary or being appointed to a position of trust, that there's something nefarious going on. And I think it's important to recognize that that's not always the case. There are some clients, and Andy can speak to this more, there are some clients who have no family. The only person that they have in their life who has any sort of financial sense or any sort of professionalism is their financial advisor. That's who they trust the most in their life. Or perhaps they do have family, but their kids are spendthrifts and they don't trust them to manage financial affairs. So there's not always something untoward going on. And I think that the FINRA rule recognizes this. And so I think that's how it changes the dynamic here.
Right. From a trust and estates perspective, I think, obviously we have to take this in two parts, right? From the naming the financial advisor as a beneficiary, I think is pretty uncommon. I can't say it's zero, but I would think it's pretty rare, certainly outside the family context. But naming them, as Joelle said, as a fiduciary or as a trustee or as an executor, I think is a lot more common. I still wouldn't say it's happens all the time, but it's more common than the beneficiary situation. And as Joelle said, sometimes the financial advisor has a relationship or a position in the client's life where they are the most trustworthy, the most reliable, the most certainly sophisticated person who can help in those roles, who can provide that service. So the client isn't looking at it as, let me enmesh the broker dealer in my financial affairs. It's just they look around at their family and they don't see anybody else who's capable of doing it, either because they're not sophisticated enough, or they have some sort of conflict, or they don't want to cause a rift among their children by picking one over the other, so they pick a third party. And often the person they look at is their advisor. So as Joelle said, it's not always some sort of nefarious circumstance, certainly in the fiduciary context. And I think that's important to remember.
Actually, Andy, I'm so happy you're here because there's so many different roles that can be played with respect to an estate. Could you help us out and talk about the various duties and roles that come up?
Sure. And I approach this from a trust and estates litigator perspective, not so much from the securities perspective. So when I hear position of trust, that can be a formal defined role that's governed by a piece of paper, or it can be more broadly and more informally, the neighbor that the elderly client relies on to help her get to the doctor or bring the groceries around, or it could be any number of things. So as far as formal roles go, we put together a little chart. You can have an executor. Obviously, an executor is someone who manages an estate. By the way, that could be an administrator or a personal representative, different terms for different states. Florida calls it personal representative. You could have a trustee, and that would differ whether it's a revocable trust or an irrevocable trust. A revocable trust is you still owe duties to the grantor, which in most cases is going to be your client here. If you notice my chart here, the only one that says grantor that really impacts your client, him or herself, is the revocable trust. In all of these other cases, you're going to owe duties to somebody else. The executor has a duty to marshal the estate's assets, pay off its creditors, and then at the end, if there's any money, assuming there's money left, distribute the money to the beneficiary. So it owes duties to all of those different classes of either people or entities, and in some cases can also owe duties to the attorney general if, for example, some of the beneficiaries are charities or if there are missing heirs. So that rather quickly gets complicated as to who you owe your duties. Trustee, you owe it first to the grantor, I would say, and then also to the beneficiaries. In an irrevocable trust, you owe it to the beneficiaries, but then you have to look at, is it the income beneficiaries or is it the remainder? And those people often have very different goals as well. And trustees have an obligation to treat different classes of beneficiaries fairly, and not necessarily equally, but at least fairly in terms of process and decision making. If you're a trustee of a special needs trust, that's in general, that's an irrevocable trust, but it has an added layer that the idea is to protect assets from disqualifying a person for Medicaid or for other means tested government benefits. So you have the Medicaid overlay on top of the beneficiary. A guardian is somebody who makes decisions either about the property or the person or both for an incapacitated person. So that's while the person is alive, you have a guardian making decisions. So they owe duties first and foremost to that person, which we would call an adjudicated incapacitated person. That's AIP, or in some states will say the ward. You owe duties to the court that oversees that guardianship. And you may owe duties to Medicaid if there's a special needs component as well. Conservator is a situation in which it is essentially, it's like a guardianship, but it's only financial. And it's usually consensual to get into a conservatorship. But once you're in, you owe duties to the ward, and you owe duties to the overseeing court. And a power of attorney is a document that creates the right of someone else to act on behalf of the principal. In this case, the principal is likely to be your client. And what we're trying to avoid here, I guess, is the agent serving as the financial advisor. So you owe duties. If you're a power of attorney, you're an agent and you owe duties to the principal. And finally, a receiver is essentially a court-ordered situation usually, and they would owe duties to a corporation. If the owners of a corporation or the management is effectively unable to run it, sometimes a court will appoint a receiver, and a receiver has fiduciary obligations to the corporation and or the shareholders. So that's a really long way of answering your question, Bev, as to what duties flow to who. It depends on what the role is. And it also depends, in addition to all these, there could be an informal position of trust, I think is the term in the rule, where it's harder to define. It's even murkier than these roles. So you got to be really careful, I think, if you are looking at what's involved here on the fiduciary side of it.
So I understand. So how does that really differ to the conversation or the points that Joelle brought up and that you brought up, Andy, the role of an FA? Because you're correct. Unfortunately, sometimes the FA does play a dominant role in a client's life. Some thoughts about that?
So as far as what's different, I mean, in some respects, nothing is different, right? Well, a financial advisor may not be operating as a fiduciary for a client, but we still want the client to trust that person. That's the goal, is to build up a layer of trust that says, I know I'm in good hands because my advisor is I trust this person. I've worked with them for a long time, and I know that they're working for me, right? Even if they're not a fiduciary standard, that's I guess a technical difference in some sense, but we do want that trust to be there. That's part of how the business operates when it's operating well for the client and for the firm. We want to build up that trust, but we have to be a little careful, not that the financial advisor has one role and all those fiduciaries on the previous slide have the same goals and also perhaps a lot more constraints and different duties they owe as fiduciaries. We also want to be concerned with fiduciaries get involved in all sorts of things beyond managing a brokerage account or helping advise as to trades or financial transactions. For example, any one of those fiduciary positions can also hold unusual assets, real estate, cash and jewelry, cars, or other things that can crash into things and causes the sources of liability. We had a trust we just settled actually, where they owned a Cessna airplane in a trust. Now that is a trust asset that is also a potential source of a fireball explosion if it crashes into the wrong place. That's complicated. That's a little more than your typical financial advisor is either prepared or equipped to take on. Sometimes trusts or estates own an interest in whole or in part in a business. Maybe they own a restaurant or a bar. Maybe they own, who knows what, a landscaping company. It could be anything. And then you get into struggles with collectibles, art, coins, guns, wine, you name it. There could be all sorts of odd collections that you might encounter as a fiduciary. And when you have those obligations, when you have those types of assets, you're not just making buy, sell, or hold decisions. You're making insurance decisions. You're making, how do we store this stuff? Is it appropriately secured? Who has access to it? Do we have an appropriate inventory? And it's not as easy as necessarily looking at a quarterly statement, which is relatively easy for a firm to generate. if the assets are liquid securities or cash. All this other stuff, safe deposit box, are frequently source of issues. Then you have record keeping obligations. You have communication obligations. In general, you have to keep trust beneficiaries reasonably informed of enough information so they could adequately monitor and police their rights. That goes perhaps beyond what a financial advisor is normally and regularly doing.
Right, and I'll just jump in there real quick, because one of the areas of this that I think is interesting and challenging is where the duties as a financial advisor can sometimes conflict with the duties of, let's say, for example, a trustee. And, I had a case recently where the financial advisor, this was actually for a family member, so would not have needed to be approved pursuant to the rule, but was appointed as trustee of his aunt and uncle's ILIT, which is an irrevocable life insurance trust. The purpose of that is that the trust is irrevocable, meaning that they can't undo it or change it. It purchases a life insurance policy. The ILIT is the beneficiary, and then the beneficiaries of the ILIT receive the insurance proceeds when the person passes away, and that's done to avoid taxes in certain circumstances. And I'll stop the share here so we can have a discussion about this. But in that instance, as a financial advisor, everyone knows or assumes that their duty is to the client. Your duty is to the client, who is the one who is the grantor or establisher of this trust. The issue that we ran into is that as an irrevocable trust, as Andy pointed out in the prior slides, your duty is not to the grantor, who's your client. Your duties are to the beneficiaries. And so in this particular instance, the family member who was the client said, I'm tired of paying the premiums. I'm going to let the policy lapse. I've given my kids enough money. There was a whole family falling out. And in that instance, the rep said, okay, client doesn't want to make the premiums anymore. That's it. The problem is that as financial advisor, yes, the duties were owed to the client and not to the beneficiaries. But as trustee, which was the second hat that this financial advisor was wearing, his only duties were to the beneficiaries and to notify them, as Andy said, about the fact that the policy was going to lapse and give them the opportunity to come up with proceeds to keep it in place. And so we just dealt with this issue in a prior case. And so for me, I think the challenging thing and interesting thing is, what if the duties conflict, and how does that play into whether this can be approved or should be approved?
Sarah, I know the minute you say fiduciary as a litigator, the hairs on the back of my head go up. You have any thoughts you want to contribute here?
Well, okay, I don't want to be drastic about this, but I think that I think it's obvious to anyone involved in these types of situations that these situations can give rise to all sorts of, conflicts, that the FA is probably not trained in issues such as what are his fiduciary duties if he's a trustee. Generally, the FA is trained on, what are his duties to a customer in connection with a brokerage account. There's not training regarding what are your duties as trustee. And I would respectfully submit that there probably should be no training regarding that issue, unless it's training offered by an outside third party, maybe as part of approving the FA doing this. The firm could require him to attend some sort of outside continuing education and get proof from the FA that they attended that. But I think it's important to keep in mind in looking at these rules that when acting as a trustee or when getting a bequest, etc., the FA is doing something that is essentially outside of his employment over at the firm, and therefore very difficult for the firm to supervise, even if the firm were inclined to supervise. And I believe that's why the language in the rule is that if you approve subject to conditions, you must supervise the compliance with the conditions. There's not really a requirement here that you supervise the person's job as a trustee, etc. Although, of course, we all know in the context of litigations, if it's his job, it will be alleged to be the firm's job. Yes. So it's a difficult situation to find the right answer to, as often the case with so many of these.
Well,
And
that
I'll
was
just
what
step
I
in,
had
sorry,
come up-
Bev, real quick. The first
Yeah.
code word is beneficiary. I will also type it in the chat. And I don't think we said this earlier. If anyone has questions as we go along that you'd like for Bev to pose to the panelists or for anyone to answer, please feel free to do it in the Q&A function. That's sort of the easiest way for us to do that. And if there are questions we're not able to get to, we can then circle back with people after the webinar.
Right. But I think Sarah brings up some interesting points, right? You're talking about potentially supervision on two different levels, right? So there's supervision about if an FA is aware that he's mentioned or named, how do you make sure that the proper notification happens so that you can go through your process? But Sarah brings up the interesting point, assuming you agree to allow the FA to play this role, whether it's for a client or a family member client, what are the supervisory issues that you see there? Any thoughts, Joelle?
Yeah, I mean, I think it's tough. You know, like I said, in the example that I gave, that was actually involving a family member. So, you know, we ended up with a problem there, and that's not even something that would have needed to be approved, or even for you know, under the FINRA rule, not under firm policy, because different firms have different policies about what needs to be submitted for approval. But under the FINRA rule, that situation, which led to a lawsuit, would not have even had to have been raised by the FA to the firm. Under this rule. So, you know, I think the question is, if you are going to approve it, and particularly with conditions, you know, what does that look like? You know, I think Sarah mentioned one particular condition, which would be to require them to obtain training from a third party on what they're supposed to do. I think the easiest thing that probably should be done is to remove the financial advisor from any accounts that they hold for that person. If they're going to, they have to make a choice. They can be financial advisor for this client, or they can serve as trustee, or they can receive a bequest, or whatever the, you know, approved status is going to be. So I think that's one step that's fairly easy for firms to supervise and to implement, is to take the person off the client's accounts.
Well, that brings up a point, Sarah. Andy, do you think that just compliance with the rule is okay, or do you think that firms are really going to have to establish or be more prescriptive in this area than the rule is?
I think to avoid getting enmeshed in lawsuits brought by family members for mismanaging a trust or mismanaging guardianship or whatever, I do think they're going to have to be a lot more than just meeting the bare minimum threshold. And that raises other questions. I mean, if you have a firm that takes on an obligation either to vet decision-making by a fiduciary that happens to also be an FA, either ahead of time or after the decision has been made, you have a real question there as to why, you know, how involved is the firm going to get, right? Are they going to veto things that the FA presents to them, said, look, I really need to send $50,000 out of this account. Here's why, and why I think this is in keeping with my fiduciary duties. And then the firm is going to say yes or no, or modify it in some way. That seems fraught with peril.
I don't want to see any of that ever happening.
Yeah. And then if you are somehow involved at that level, you know, you start to wonder, why are we effectively acting as a fiduciary here without any of the upside? You know, I see my private wealth colleagues on the other half of the bank, that we have a trust department, we have trustees, we have trust officers, people who specialize in this stuff. So why are we doing this more or less informally with one of our FAs serving as a fiduciary, but we're not receiving any of the benefits that we would normally receive? We're not getting paid to take on this additional fiduciary risk, but yet here we are making fiduciary decisions, or at least, you know, approving them after the fact or second guessing them or whatever. I see very little upside for a firm to get involved in that.
And generally speaking, we are not set up to supervise whether a trustee is doing his or her job properly. We are set up to supervise whether we are properly dealing with customers in the context of giving them investment advice. And so I feel that it creates all sorts of problems, but the firm, in any situation in which the firm is responsible for supervising the decisions of an FA as trustee, as opposed to an FA. And therefore, to me, the first thing that I would recommend doing in a situation like this is, if you are going to allow the FA to act as trustee, then he should not be permitted to continue to service the account, because that's probably where claims of conflicts and wrongdoing are most likely to come from. And, the person will have to make a choice as to which they do. Once there's somebody else servicing the account who is, being supervised in the normal way that they are, frankly, there does not seem to me to be a duty under this rule to really go around supervising whether the FA is performing properly as trustee for the trust.
So as in-house counsel, I have to tell you, I see a number of things here. Number one, with respect to notification or even being aware, this feels a little bit to me like selling away, right? Which is oftentimes you have to rely on other people to tell you about activity that's going on, right? Because here, if the FA knows, and we know people have very differing attitudes about money, all right, I will speak for me. I was a grown woman with grandchildren, and my mother still thought I was 10 years old and didn't want to talk about her arrangements. So, I mean, you have that natural reticence to talk about the arrangements that you've made or the money that's there. And so one is you're liable not to know that it's going on. Two is if you say, to Sarah's point, well, you can't be the FA on the account. Now, in my mind, you've got an outside business activity, right? And what are your concerns there about this outside business activity and what kind of liability it may potentially open yourself up to? This is what I see. So I mean, I can see firms deciding to be very restrictive and saying, no, you can't do any of this because the supervisory problems are just so immense.
Yeah, I agree. I mean, it's hard to get around. I mean, how deep you have to get, and we all know that it's easy to get sued, right? How fast and how quickly and how efficiently you get out of it is usually the question. People could sue you for anything, right? So if you've approved a fiduciary relationship and put terms on it, I think it's hard to say that you don't have some implicit obligation to monitor it and supervise it as well. I don't think it's the stamp of approval and then you forget about it is enough.
Right.
It's going to be hard to defend that if you get enmeshed in a lawsuit or a claim in arbitration later.
Yeah, and I think in terms of
Another thing
customer, oh, sorry, go ahead, Sarah.
with this is if you are going to prove it, give the customer something in writing. Okay, the person is your customer. It's not some complete stranger out there. Give the customer something in writing that says, this person, you want this person to be the trustee for your trust. Please understand that in performing that service, he's not acting on our behalf. We will not be supervising his decisions as trustee. If you want somebody with expertise in this area, blah blah blah, go to the trust department or go to some other place. In other words, something in writing that you can point to assure yourself that should there ever be problems, that the customer knew and that the customer was not confused regarding who he had appointed as trustee and whether the firm was involved in performing the trustee function.
Joelle, you had something?
Yeah, well, I think this kind of brings us sort of to the litigation risk here, and on the customer side, kind of to Sarah's point, that's good in practice. I think the issues with that come up, and I think Andy can speak better to this about, what are the types of claims you're going to see? I think one is claims of undue influence or diminished capacity, which I'll let Andy talk about more in a minute, since that's sort of his universe there. But I think when you're going through this, the kind of selling away outside business activity approval comment, Bev, that you made, I think is spot on. And I think when you look through the sort of reasonable assessment criteria, which FINRA is quick to point out is a non-exhaustive list, I mean, there's all these things you need to analyze, and could be other things you should be analyzing, to determine whether this should be permitted or not. And so I think, one of the major issues, if you're going to see this come back in customer litigation, is claims that the assessment the firm made was not reasonable or was not appropriate. You didn't properly analyze this criteria. You didn't properly analyze that criteria. Conflicts of interest, I think, is going to be a big one. That one I think is very tough, particularly because the people who are making these decisions, let's say it's a branch manager or a regional manager. I mean, do they know what, I mean, we had a whole chart. Andy just spoke for, about 6 minutes on all these various duties. I, as a non-probate lawyer, am not intimately familiar with all those duties,
Yes.
So I think to have non-lawyers making the assessment, do these duties conflict or not, is troubling. I think that is, and to Andy's point, is fraught with peril. But I think that there are a lot of these criteria which, if this comes back, and I think Andy's point is a valid one, which is, there's very little you can do to avoid being sued. The question is, how good is your defense going to be once you get there? But I think there's a lot that you'll see claimants' attorneys pick apart saying, well, on this particular criteria, you didn't do X, Y, and Z, and you should have. So I think that that's, where a lot of the risk is in terms of customer claims.
Well, and also from an in-house perspective, or at least from my perspective, is sometimes these things come in and they're in, so I'm licensed in New York and we have a surrogates court, right? So you've got a surrogates court action going on where maybe the heirs are contesting various and sundry things. But that doesn't mean that you're immunized on the arbitration side, right? Because then you've got all of your traditional suitability, supervision, whatever roles. So to Sarah's point, from my perspective, this is really potentially being in multiple forums, right, with pieces of what's the same fact pattern. Did your, how well did you supervise? What's the state of the assets and everything else? So for me, from a litigation perspective, I tend to want to say, you don't get to do these because there's so many different areas of liability for a broker dealer. And the other thing I wanted to say was this is going to fall on broker dealers differently, right? So I'm Wells Fargo, which obviously has a robust trust department. It's almost like a little bit of a conflict there, right? In terms of counseling the client in your FA role, because one of the things that we say is, when you're talking to your client, be mindful that there may be other services available that Wells Fargo could help. So there's even a bit of a conflict of interest there, wouldn't you think?
I do think, and we have a question, actually 2 questions in the chat here. One of them is related to that. It said, could the firm charge for services similar to a bank trust department? I think, well, the trust department can charge for these services. I don't think the bank itself can charge, or the firm could charge for it monitoring its FA who is performing these functions. In general, fiduciaries are compensated unless they're set up as a trust company. There's a state will have a statutory matrix for how a trustee or a guardian or an executor is compensated, and it's a mix of how much assets or how much in assets is the fiduciary managing, and then there may be a component related to either income or distributions out, tax either coming in or going out. So I think your FA could be getting compensated under that statute, but I don't think that the firm itself for monitoring this is going to see any of that. I don't know that they even could compel the FA to split it with the firm in some way. We're going to talk about employment issues and how that gets sticky later, but I think you have a real challenge saying, all right, we'll approve this, but you have to give us half of your commissions. That's going to be, you're going to get in trouble for that, I would imagine too.
Yes, that's true. So since we're in the world of litigation, which is, I think, the background of everybody here, let's talk a little bit about the kinds of claims we could see. So Sarah, want to talk to us maybe a little bit about the customer area?
In the customer area, it seems to me that one of the easiest things to predict would be claims in the nature that the firm should have been supervising the actions of the FA in performing as trustee because the firm approved the FA performing as trustee. I don't see this happening so much in the area of approving a bequest, because I mean, generally, that gets found out before or after the fact. I don't see that coming so much. But from the standpoint of supervising because you approve the activity, I mean, that's the obvious claim to make, right? And I don't see any way to avoid that other than to quote Nancy Reagan, just say no. But that's not necessarily always desirable or practical in the real world situation.
Yep, I can certainly understand that. And Andy, I mean, in my firm, I know there's a lot of focus on senior investors, because I don't like the word elderly, but on senior investors and a lot of the issues they bring up. And what I've seen in my practice is lots of undue influence claims. Usually it's, aunt against uncle or cousin against sister or whatever it is. Can you talk a little bit about that sort of litigation?
I can. I just want to, before I dive fully into that, we had a case a couple of years ago where we were representing a client, one of our firm clients, and in a situation where a former FA who had since moved on from that firm, but the client stayed, was serving as power of attorney for the client, and so was his daughter. And we discovered this after the fact because the prosecutor came to us and said, we're seeing like $35,000 a month come out of this account under the direction of the power of attorney, and it's going to another bank. And from there, apparently, this guy was writing checks totaling almost $900,000 to cash or to himself. And when we questioned him, and he was dumb enough to sit for a deposition without a lawyer, so there you go. He didn't have any receipts. He couldn't show why this $900,000 was actually used for the benefit of his 90-something-year-old client, who was a client of our firm. So we brought a lawsuit on behalf of the firm saying we see what we're pushing into our end of the pipe at the direction of a power of attorney. Judge, you need to cancel this power of attorney. We need to appoint somebody who can connect all these dots, because we kept running into privacy concerns. The other bank couldn't tell us what was going on their end. They were kind of like, look, we're seeing red flags, but we can't tell you what. And then we talked to the prosecutor and they wouldn't tell us what it was. And then we tried to get medical information and we couldn't get it to see if this lady had something, either Alzheimer's or dementia or something else that was limiting her capacity. So it was a real challenge. So we ended up spending a fair bit of firm money to try to rectify this. And we think we did the right thing for our client in that case, but at a fairly significant cost. And what a can of worms. I mean, it wasn't exactly the same situation that this rule would cover, because the client was at one house and the broker now was at another. I guess would have been a crack in this rule that he figured out how to get through. But I mean, it can be an enormously messy situation if you discover one of these things that has gone wrong. Now, as far as undue influence in general, a large part of my practice is dealing with undue influence claims and people taking advantage of senior investors or vulnerable people, however it is. So in general, to show undue influence requires two things. I'm speaking obviously as a New Jersey lawyer, maybe slightly different. It's going to be close. You have to show a confidential relationship. That's what we've been talking about the whole time today. And the second thing you need to show is what we call suspicious circumstances. So confidential relationship, as we mentioned, can be a formal arrangement, power of attorney, guardianship, trustee, however it is, or it can be more informal. Financial advisor to client, even without a formal arrangement of some sort, if that financial advisor is named as a beneficiary, is going to check that box for undue influence litigation. And then suspicious circumstances, one of the hallmarks of that is an unnatural distribution of the person's assets or gift of the person's assets. So a gift that's flowing to a financial advisor is going to check that box as well, especially if there are family members or somebody else who's related to the client who's going to be able to say, well, wait a minute, why is Aunt Mabel giving all her money to her financial advisor when I'm her niece or I'm her nephew here, or there's kids or whoever it is. So I mean, this is why the beneficiary situation is not, I wouldn't say it's all that common that a person comes to us as T&E attorneys and says, I want to name my advisor as a beneficiary. And we would, I think, make them think long and hard about that, understanding that the beneficiary is not likely to be able to claim that gift as a financial advisor. But sometimes you get in the situation where the client says, nope, that's it. I'm leaving it to my advisor because he's served me well over these years and I want to take care of him or his kids or whoever. I had one like that recently as well, where we had to actually file a guardianship in Westchester County to have the advisor named as guardian of the property of his 2 minor children. And this is a very high level guy who was making, easily making 7 figures a year. And he did not need this $25,000 gift to his kids. They had well-funded college accounts. They had everything lined up for them. They're in private schools and all that. So we had to file an application for 2 guardianships for the kids in one county, and then disclaim the gift and file another application in New York County Surrogates Court to disclaim that gift. And we had to do it all within the 9-month time limit that the IRS puts on disclaimers. Enormously complicated, expensive litigation that it just wasn't, and he didn't want this gift. He even told the guy, look, I can't take this, you can't leave it to me. And his very, very stubborn older French client said, no, we're going to do that. And I appreciate your service and I am going to take care of you. He said, please don't take care of me. But there was nothing he could do about it. And we looked into it and we had to do all of this spinning to try to get out of it. And and obviously when we got involved, we looked hard at the FA to see if there was something suspicious or nefarious here. But he had a sterling reputation. He convinced us, more than convinced us, that he was on the up and up, and this was not something that should have been an employment action against him. So we ended up doing all this work to clean up this situation, and it took a long time. It cost a lot of money.
Well, I mean, this whole area brings something. I remember when I was in law school, the thing they drilled in is that you want to fulfill the testator's wishes, right? This is the paramount thing. Right. And this rule sort of puts a spike in the middle of that, right? Because you can have a person very much like the situation you described that wants to do this thing. And even when you say, no, don't do this thing, has made up their mind of what's going to happen. And now the FA, the firm, are faced with trying to mitigate or unwind the situation. I want to be mindful of time, but Joelle, let's talk about the employment claims, because I've had some familiarity with situations where we have said, no, you can't. And one of the risks that you take is an employment claim. So let's talk about that for a second.
Sure. So, and I'll give the second code, which will be trustee. I'll put it up in the chat as well. So in terms of the, kind of what I think are probably constructive termination claims, impossible choice claims, and how those impact promissory notes, I'll let Sarah speak to that. One employment aspect I did want to cover, though, which actually was something Andy brought up, comes in the recruiting context. And so Andy had said, well, this guy had left the firm and was at a new firm. So actually the rule, and this I think is also very challenging. You probably remember from the slides, if a status has been approved at a prior firm and that FA moves to a second firm, like in Andy's case, that FA has to get the same activity approved by the second firm within 30 days. And so to me, I view this as being very challenging because first of all, you can run into these claims where, you knew I had this status, you knew I had this bequest, you told me, don't worry about it, it'll be approved. Now I'm here and now it's not approved. And although the rule says this all has to be in writing, you're going to end up getting someone saying, well, they told me not to worry about it. And, sort of wink, wink, nudge, nudge, we'll get it done. I think on the other hand, so I think the practical advice on that is, those are things that you need to sort out before the person gets there. And although they have 30 days from starting with you to submit a request, that's something that needs to be brought up front. But I do think that creates its own challenges because if the firm is inclined to undergo this reasonable assessment, well, how can you really do this assessment on someone who's not a client? You don't have access to their financial records. You can't see their account statements. How do you know anything unless the client's willing to turn it over to you? But typically the financial advisor is not going to announce that they're looking to leave to their client. So I think it's very challenging to deal with those issues up front in a meaningful way, but also creates kind of recruiting based litigation risk, if you wait till the person gets there.
No, I understand entirely. I mean, this is another category of information that you would like to know during the recruiting process so you can make a reasonable decision. Actually, so all parties can make a reasonable decision, right? Because if you're an FA, you want to know or have some idea what the firm is going to say. And certainly as a firm, the less surprises you have during an onboarding time, the better. But the privacy rules don't cooperate with you there, right? If you come from a non-protocol firm or if you have certain types of employment agreement, the privacy rules don't allow you, to your point, to disclose probably the information the firm needs. And so now you've hired somebody and they have a situation and the firm is saying, we want nothing to do with this. So there's some tricky things to navigate there. But Sarah, I want to give you your moment to talk about the fun litigation we're going to have in the employment arena.
Yes, of course, because just say no, of course, has a downside, no?
Yeah, absolutely.
And the downside is going to be that, let's start with the easy downside. Sometimes a customer decides to leave a bequest to an FA or to name an FA as trustee for a revocable trust, for example, and they don't tell the FA. They didn't tell the FA. The FA can't ask for it to be approved, right? Now the customer passes away and the FA is going to get a bequest out of nowhere. Let's assume it's a sizable amount of money. So now the firm, having a just say no policy, takes a look at this and says, no. On there is that's going to give rise to a claim by the FA, because the FA is going to claim that, you're forcing me to choose between keeping my job or giving up this money that I didn't even know I was going to get. So there was no wrongdoing on my part. And, if he doesn't want to accept your instructions, obviously he'll be terminated. So then he'll claim that he was constructively terminated. And then, God forbid he has a promissory note that he has to repay when he doesn't work for you anymore. Now, when you try to collect the money that he owes, the person will claim, once again, they were constructively terminated and they should be discharged from their obligation under the note. Same thing if the FA does know and the FA asks for permission to perform this task. I think that I think that if the FA is just going to be a trustee, the FA is going to lose the account to someone else there. I think that the FA probably would be grateful that the firm said no and that he could not take that job, because really there's nothing in it for the FA at that point other than a headache. But if you're talking about a situation in which there's a bequest, again, you could find yourself in the same impossible position of, if you approve the bequest, then are you going to have claims from other heirs? Once there's a death by the person, are you going to investigate whether the customer has, is subject to some sort of undue influence by the broker, or whether there's, some sort of issue here with the bequest from an inheritance or a probate perspective? If you are going to investigate that, just how are you going to do that? Since I go back to the fact that we are set up to supervise the behavior of people giving investment advice. We're not really set up to go around, as private investigators for the private motives, private family motives of our customers, although we are often involved in those. So this is going to present issues no matter what you decide to do from the standpoint of litigation, because you're either going to have issues on the customer side, possible issues anywhere, you're going to have possible issues on the employment side. And if you're really lucky, you may actually have issues on both sides of that equation.
Well, you do have a customer problem
What's
too.
your problem?
Yeah, one point I was going to bring up is sometimes, the FA will say, well, I'll assign the money to my wife or to my kids. So in other words, it's not me. And that's kind of a solution that's not a solution sometimes, right?
Right.
Yeah, I interrupted you. I didn't mean to do that.
Yeah, no problem. I was just going to say, from the perspective of the client, you have an issue if one firm approves a financial advisor serving as guardian or serving as trustee, and maybe you even have a court involved that's sort of coordinated and blessed all this, and then that person changes jobs. Now you have a situation where that person may not be able to serve as guardian or as trustee, and then the client is really left in a really bad spot.
Yeah.
And you may not even be able to get out of it that easily, especially if it's a court appointment like a guardian or like a conservator. Power of attorney, I guess, is one thing, but if you signed a power of attorney and now the person is incapacitated, you got a problem, and then there's no easy fix for that. So that I guess is an employment related, it's a change of employment related issue, but it really risks a lot of chaos on the clients, or could.
Well, that kind of brings us to a point. So to the extent that you might be counseling a broker dealer, do you think that compliance with the rule is enough? A stricter approach? Thoughts about how broker dealers might look at their risk here and make some good decisions? Sarah?
The only part of this rule, and I'll defer more to Joelle on this point, but I think that she should discuss, the fact that this rule does not particularly address issues of serving as trustee or getting bequests from family members, which is, to the extent that we're talking about elderly customers and a concern for elderly customers, this rule really doesn't do anything for that situation. What would you say, Joelle?
Yeah,
I agree with that. And if I could have a second,
absolutely.
I think somebody pointed out most of the issues we have around potential abuse, financial abuse, involves family members. Go, Joelle.
Yeah, and that's exactly what I was going to say. Anyone who does work in the area of elder and vulnerable clients knows that I think the statistic, and depending on where you're getting it from, that the most likely people to commit exploitation are family members, and of those are adult children, who are also the people who are typically appointed in these roles. And so, there was a NASA comment letter to the rule before it was enacted, basically saying, and NASA essentially said, this shouldn't be permitted with anyone who's not a family member, and for family members, it should specifically be approved. Now, obviously, FINRA declined to go with NASA's view on what the rule should be, and made it broader, but I think it sort of raises an interesting question, which is, should approval extend to family members as well, if those are the ones who are most likely to commit exploitations, but statistically speaking, and if that's what this is really sort of designed to prevent. So, under the rule, if it's family, they don't even have to disclose it to you, right? Under the rule, that's not, firms may have separate policies about what's required to be disclosed or not. But, maybe it should be, and that's something that firms sort of need to look at in terms of a risk perspective. And oftentimes when you get these suits coming back, they involve family, saying that the financial advisor was a family member, but because they were in this financial position, they exerted more influence than the other disgruntled children who didn't get as much money. So I think it's a fair question to ask and to look at. And I did want to ask, just answer one quick question that came in the chat. There was a question about, do firms get any safe harbor from the new rule if after a reasonable review, it just can't get comfortable with the bequest or position of trust to a current FA? This goes also to Andy's point about the change up when FAs are moving firms. So the default under the rule is that FAs are not allowed to accept this period. The only time they're allowed to accept is, one, if it's immediate family as defined by the rule, or two, if they seek and obtain approval from the firm. So the default is that the answer is no unless you get approval. But as we all know with litigation, that what the rule allows is not always, a barrier to litigation. So I think while, the default of the rule is no, they're not, unless you get specific approval, the answer is no. I don't think that immunizes you from lawsuits in which, someone you've recruited is going to say, well, I know that this rule exists, but I was told by, Joe manager that it wouldn't be a problem and not to worry about it. And based on those representations, I left my prior firm. And to Sarah's point, if when that person doesn't get to serve in this position or doesn't get that bequest and they decide to leave and they have a promissory note, then this all rolls into, this big fun employment balls. So I think it's,
Absolutely.
yeah, the answer is really, what can you expect in terms of litigation, which is not always consistent with what the rule allows or doesn't allow.
No, this is definitely a situation where no good deed goes unpunished, right? There's just no good way. Well, I see that we are just about out of time. Thank you so much for a great discussion.
Guys, we have, I'm sorry, one more question in the
Sure.
chat that we missed here, it looks like. Yeah, and then I'm not the one to answer it, so I'm just going to field it and you guys can answer it. If a member approves an FA having this type of arrangement, is the FA in a business? Does it require an OBA as well as a U4 disclosure? Just want to make sure we got to that one.
I don't know the answer to that question because I had not contemplated it in advance of this. It seems to me it's not an OBA because there's a specific rule that discusses this, and there is an OBA rule. So I don't believe it is an OBA. Whether it has to be disclosed on the U4 or not, I would have to look to see if they've made any arrangement, any amendment that now would require that. But absent an amendment, I don't really know of any place why it would have to be disclosed on the U4.
I am not a registration expert. That's something I'd have to take back and ask the registration folks as to how they think something would be approached. I mean, I think I brought up OBA only because if you were going to engage in that activity, you probably would want the firm would want it to be disclosed. But I think there you'd have to look to the firm's policies and procedures. Okay. Well, once again, thank you so much for a great discussion. You've given us lots of information and lots of things to think about.
All right. Thank you,
Yeah.
everyone.
Thanks, everybody.
Thanks. Bye-bye.